Sorry. When was it disposed of? 11. Should have been out right now. Very well, you check up. You check up. Should have been out. Yes, yes. What was signed? Very well, you'll find out. You'll find out. Yes, yes, item 62 at the request of Mr. TKD. Matter stands passed over for the case. Forty 1-4. 1-4. Passed over at the request of MS A. Das. Matter stands adjourned. All right, it will come up on 25th for admission. Yes, what happened? Passed over at the request of, you're mentioning on whose behalf? PHR for the petitioner, matter stands adjourned for the day. Mr. K. Bonita for the respondents. Yes. For correction or disconnection. Okay. Tomorrow. Let it be on Wednesday. All right, tomorrow.
Daily list promotion item 1.
At the request of Mr. Gautam S. A. Gautam. The matter stands adjourned as it is submitted. The petitioner does not wish to press the document. Yes, does not wish to press the petition any further. Accordingly, the petition dismissed as withdrawn. No liberty. With liberty.
Item number 2.
Yes.
First, and if we feel application was either rejected money, case 15 in the rejection order money, process pre-petitioner for earlier money. Transfer given very paid and the father pays with a senior 60 pays rejected money. At this stage, I pay money whether
CD. CD not available. Our general counsel for the parties call for CD. And medical injury report. Where is it coming from?
for Hajuma.
Haju. So tell us a date when you can get it. 28.
Let the people also appear recording statement.
We don't know. That's the whole purpose. What? Let us see the FIR.
It was a quarrel between the families, mother, it is the FIR man. It is the.
Okay, hard learned councils interim. You appear within 10 days, this on 25th of September.
Apply.
For admission, item number 3.
The question of the gap seven the data is temporal email of the regular question of the and some other person have been.
So nothing remains. It is submitted by Mr. S.K. Das, learned counsel for the petitioner. And Mr. Dimki appearing for the respondent, 1, 2, 3. That the petition has become infractuous, the same. The petitioner does not wish to pursue the same any further. Accordingly, this petition stands dismissed as infractuous. Interim order, if any, stands vacated.
Item number 4.
Yes,
Last to have a person at 170.
yes, who is appearing for respondents? Some appeal has been filed. What is the status of the appeal? You get it by 2 o'clock. Get it by 2 o'clock. You contact me.
Election and place.
We have filed the affidavit, para number 13 of our affidavit.
No, kindly go through the order, last order. Appeal was filed. By the respondent.
Yes, in regard to that, we have already mentioned our affidavit,
Error number,
para number 13.
affidavit filed by
Affidavit filed by CDP also. It is respondent number 6,
6, all right. Error number 5,
para number 13.
13.
Page number. Next to state that it is a fact that applicants will file by respondent number 8. Page number 6 is the election and program inspection with the government conference also already it was appeared that there is an appeal filed by the petitioner of probability. You see the private respondent, we is still pending for disposal. As the appeal is still pending and the court filed or the so director committee secretary to take a decision in respect of the appeal filed petitioner but concerns are also extend this petition. That there were lot of errors going on with regard to selection of appointment.
No, what is the status of the appeal? What happened to the appeal?
It was also cleared by the election and page 66.
Some appeal was filed, what happened to that appeal? That instruction will be required. If possible, get the order. In the meantime, perhaps,
There is a direction my lord, to dispose the appeal within 1 month, page 66 election.
appeal filed by,
That's part of
Number 8,
yes, probability. Yes, sir.
but they are the joint appeal along with one.
No, it can be disposed of on merit sources because our extent is very clear. Also.
no, what is the decision?
First, I'll get it lost. What is
that-
the status of the appeal?
That is what we want.
First, I'll get it there.
Get it at 2 o'clock.
Yes.
At 2. Let it come at 2 o'clock.
Item number 5.
Minimum here expired, so will be subsidiaries wife. Our basically, that he was not provided an opportunity in the sense that. this is-
Wife has already been substituted.
It happened, there was an allegation of harassment, sexual harassment.
Hmm.
In a public bus. So
He
there
had,
is an allegation of sexual harassment. of a student matter, in a public bus. Now, my lord, accordingly, the ICC was instituted. The ICC, without serving a copy of the complaint matter, we need to ask him to make some statements. On the basis of that, one of the appeal order has been passed, moving into the compulsory time service. So our basic case is number one, that it is not a box, it's no one. Number two, my lord, the basic requirement of serving a copy in terms of the Rule 7 letter. Of the 13 rules that were not followed. And my lord, there are also a disciplinary proper disciplinary proceeding in the city and city.
Where is the impute order?
The appeal order, lordship will find. My lord, page 13.
This is rules.
He was asked to go and leave. Then, my lord, he was informed that he used to be getting to the ICC. And he shared through my lord communication. But February, he was asked to get to the ICC. But my case is the ICC may be raised by such statements. I was not given shown the copy of the bill of complaint.
What was he working as?
You know,
Okay.
and then my lord, been already passed that. Because the records were produced, my lord, and the but perhaps not records that shown never to show that the book notice was stopped in the factor. I think was more important to fact. But in the ICC, he was told that the girl has made a complaint never that gave some misbehaved. And he was asked to take a statement saying that statement that are asked to make.
It says some inquiry was held.
Nothing, no, that's only the ICC level. That there is a copy of the complaint level, because that's why Rule 7 level is required to be given over.
Yes, Mr. Kyan. He doesn't say anything about the ICC has arrived at a conclusion that he was guilty. Thereafter, not correct, but pursuant to that, should there not be any inquiry, further inquiry?
Some judgment prosecuting have that. I think the recommendation is fine.
Which was,
In fact, if there is no service, would say there is no service to the inquiry will not is not required. But if there is service to the inquiry, number one. Number two, my basic case is the complaint on the basis of which I was removed or also retired. That complaint was also not following a serve. And as per the rule, major the rules were within 7 days, this complaint has to be given allowed for or my reputation, whatever. But under the section, there are similar views of women and workplace goods property. Rule 7 is very specific, man. Once the complaint is made, a copy was of the same has to be given to the person concerned.
Very
Rule 7 works.
Because earlier I produced
You tell us when you can produce it. After a week, when September. Matter be listed for hearing on 12 September, on which date? The council hearing for the Assam University will produce the relevant records. If for perusal of the court, if we find. Third, the council services.
Item number 6.
Huh?
Case length in talk about one word.
All right, time being.
7. Item 7.
You are to file a rejoinder affidavit. It says no, not file.
Yes, I have.
You file. One is affidavit of opposition, affidavit and opposition by respondent 7.
Yes.
You want to file rejoinder against whose affidavit?
Number 6 and 7.
One affidavit, two separate affidavits.
Yes.
They are not here. It is submitted by Mr. S. Islam Learned Counsel for the petitioner that the rejoinder affidavits in response to the affidavits filed by respondent number 6 and 7 has been filed on 8th of June. Stop, however, the same are not available in the case report. Registry to verify and trace out the affidavits stated to have been filed and connected to the case report. Mr. H. A. Ahmed appears for respondent number 6. You have received copies. It's not here. List after 1 week. After 1 week.
Items 8 and 9.
Manapia is passed over for the petitioner. Mr. B. Chaudhary for the respondent PDCL, Mr. H. Chakraborty for 2. You are appearing? Yes, please. Yes, tell us.
We file affidavit in reply. The affidavit of vision filed by the respondent.
You have already been granted time earlier.
Still for it, but somehow it witness.
MS so and so learned counsel appearing for the petitioner is permitted to file the rejoinder affidavit within 2 weeks from today. Mr. Chaudhary, Mr. Chakraborty appears for the respective list after 2 weeks. And who appears for item number 9? Mr. Mohanto. Right. Item 9, both the matters.
Instruction from the next week.
Appointments have been made, we file a detailed affidavit.
You get it by, then you get it by 25th. Get your instructions. 2 weeks. 2 weeks is for filing rejoinder. You want instructions to find out whether these are still alive.
Right. And for my.
Then you get it by next week. Matters be listed again on 28th of August.
Item number 11.
Regarding my lord, the belief and something. Yeah, my lord, the affidavit submitted by the respondent number, my lord, 1, 2, 3, and 4. The first affidavit, my lord, this employee did not, my lord, furnish the particular and family details of his family. Therefore, my lord, the petitioner, my lord, because of lord, is admittedly, my lord, wife of an Indian, my lord. This family person was not settled.
First wife, second wife,
No, my lord.
only wife. Yeah.
Only during my lord, his lifetime, my lord, the petitioner before the lord, my lord, was compelled to stay, my lord, with her, my lord, parents, my lord. Therefore, my lord, after death of the, my lord, husband, she is claiming. My lord, I am claiming, my lord, better with the issue of, my lord, related to the department, my lord, after verification, my lord.
You were separated from your husband,
Yes, sir, that, my lord.
but you were still the wife.
Yes, sir.
Any orders from the family court regarding maintenance or any criminal court?
No, my lord.
Was any maintenance provided?
My lord.
Was any maintenance provided?
My lord, lots of maintenance was provided.
Yes, what is your stand, Mr. Kiel?
Our first time that we was not giving it a respect.
Maybe
Secondly, here the image there.
she has remarried
Yes, and our son is also very, looking for.
or
Claiming, family pension. And the son said that she has already been making. I will give not that. Father-in-law also filed an application. She has no connection with the son. So they want to pay this.
Yes, my lord, I may be allowed to submit, my lord, decline.
page number 35, your son says you are remarried.
Yes, my lord, I have to submit it.
Huh?
Yes, my lord, I get to submit my lord, affidavit.
What affidavit?
Yes, my lord, I have to verify, my lord.
What verify? You're making a statement on oath.
No, my lord, I have not gotten it stand, my lord.
You said you are the widow of so and so and you are claiming the pension.
Yes, my lord, only my lord, he is saying that, my lord, petitioner, because your lord, is already, my lord, married elsewhere. My lord, if this, that is correct, my lord, then definitely, my lord, he is not a candidate. I have to take, my lord, the civil instruction.
Friday, get your instructions on Friday. Friday,
Monday.
Friday. Try to get it. Why, what is the point in keeping matters like this? List on Friday, on which date Mr. Orvia will obtain instructions as to whether the petitioner had remarried after being separated from her late husband during his lifetime. Mr. Tial, it was for the response. List on Friday, 25th.
Items 12 and 13.
Yeah, good morning.
চাইন টো হৈ আছে নচিব এইটো আপুনি চেক কৰিব কৈছিলে সেইদিনা যোৱাৰ আগত তাৰপিছত হাতী তাতে এখন প্লেচ কৰিব কৈছিলে চাইনটো 11 তাৰিখৰ অৰ্ডাৰ আছে কিবা RPF ৰ কিবা এটা হেৰি আছে
You should get it up to date. What is this? Councillor mentioned, what is it called? Oh, you will.
কিন্তু পুরো চেক করি স্যার
Yes. What is the matter?
Phone number.
response has been selected above the petitioner. Considering the fact that the petitioners scored more marks than the private response. Whereas in our affidavit, of they made it clear, although the marks is higher, but when it's come to the reserve is up. Private respondent belong to OBC and C and the
Petitioner,
petitioner is only the category. So not C. And giving the OBC percent is more than the part of part. And the petitioner being the unreserved category, although she got 69 marks, was below percent in her own application. Like after marks was 70 or 70 marks.
who's
The petitioner
and private respondent?
belongs from OBC category.
No, marks.
Marks, total marks is also 50.
Then. Is the post reserved? Is it reserved? Was the post reserved? How many posts are there? Alright, you file your affidavits, Mr. M. Dr. Counsel appearing for the private respondents. Claims leave to file affidavit or is it affidavit?
10 days time. 10 days time. I think you'll say week.
10 days time, to file their affidavit. This after 2 weeks. MS Renfro appears for the petitioner, Mr. Sharma. Borua appears for the respondent department. After 2 weeks. There are two matters. Cross.
No problem, the two petitioners are challenging my appointment. So then one of them.
You are appearing for both the petitioners. You are appearing for both the petitioners. This. For 2 weeks. Your date after 2 weeks.
11th of September. Item number 15.
Who's appearing? At the request of MS Renfro. You wanna like pass over, okay? Pass over.
Item 16 to 21.
Thank you, Lord. Look, this is the petitioner, right? Object should be a wage cut possible. That wage cut was definitely good. And these are number of the other cases are also filed. In that one of the case, 1094, these are also after an order that you could initiate a disciplinary proceeding, and only after the conclusion of that proceeding you can inflict this wage cut. You know, pursuant to that order, somewhere all employees, earlier orders have been apart. So, we have to amend that order. We are incorporate that order. Probably I'm not clear to you.
There was some wage cut.
Wait, and this way.
One of the petitioners approached the court and this court directed that you hold some inquiry.
Yeah.
And then pass some orders. Now you are similarly situated. So pursuant to that inquiry, some order was passed, fresh order. So these have become infructuous now.
No, that order was passed, 1094.
Correct.
Now, we have to challenge that order.
You are to challenge which order?
Absolutely.
The order passed by the department pursuant to 1094.
Yes.
So these, what is your prayer here?
This one who could have passed in order.
This 1094 is here. We have a copy.
1094 is not here. That is district of-
I know, we have a copy here.
Here.
Copy is available here. So we can dispose it off in terms of this order if you want, or essentially the petition has become.
You have to file another immediately.
So this petition has become infructuous.
It happened like that. After with the 7 days, then all of you will not make a take tomorrow.
Tomorrow.
or yeah.
Seven requisitions were filed. And four were disposed of with these orders, 109.
Where is that impugned order? Impugned order? You are challenging some letter dated 29/1/2021.
42. Page 42.
42.
Same order is challenged in all the big.
Inquiry order. So what happened in this case, sir?
Hmm.
The petitioners were working as a handling workers in Newbury, who for a before FCI.
So it was interfered on the basis of Rafik machine.
No, not.
Hmm.
No. They did not hold it in.
And that is why I have
Every pension is kept off.
Rafik machine.
No. Because it is the question of fraudulent payment. So it is not covered there.
Or your worship can fix a date, more or the other. Your worship must expose it out.
Where is that impugned order? Page number 42. What is that impugned order? Just pointed out.
What it was there during the.
No, impugned order. Yes,
Page 42 is telling.
42.
A large number of persons are involved in this case. There are about 100 workers.
So this court directed no action to be taken on the audit report dated 25/10,
Yes.
2014. And it is in pursuance to this audit report that action are being sought to be taken against you, which are impugned.
And the following board.
So this audit report, whether to take an action or not,
No,
is a call to be arrived at by the officers after the inquiry.
that was done now.
That was done.
That was done now and it's to challenge that. It is inquiry that the order was passed, so it is to ask. Actually, these are because impacted. I think the petitioner may amend the petition either or for file a first thing challenge. The last order was also like that.
25, 25.
What is part is order, the last of the.
Eleven 2022. For holding the disciplinary also means they have affirmed the earlier. Thank God.
But the audit note was not interfered with. Audit note was not interfered with.
No,
No.
You take your instructions, we can have it on 25th or 20, when do you want it, 25th?
let it not be on 25th.
Day after tomorrow, we can have it, you can get yours.
Yeah, after two.
Yeah. List on 23rd. Enabling learner councils for the petitioner, Mr. Dasgupta, to obtain the instructions in respect of the actions taken by the department pursuant to the directions given passed by this court in the WPC 1094 of 2021.
There are other methods. Up to 21.
Yes, 16 to 21, yes. 23, or is it 21? 21. 16 to 21, all right.
Items 22 and 23.
In this matter, for several occasions on 60,003, last month was given the final affidavit. Earlier, 4 more successful given, but no affidavit.
There is a lordship. In this case, I am preparing for the private respondent. I am simply for the 3 weeks back. I am already sort of concern from his CD.
Why 3 weeks?
The lordship, this nurses are scattered all throughout your lordship. And they don't get leave because of the nature of the duty. So I have contacted them. They are coming in the next few weeks, few days. In the meantime, I file that.
You are appearing for
The private respondent.
9 onwards.
In item number, in petition 2940, I have filed my wakalat now. Within 6006 of 21, that is item number 23, I am yet to file my wakalat.
The affidavit of the state is also.
Who is appearing for the association? You are appearing for the association
Yes,
also,
Your Lordship.
huh?
Yes, Your Lordship.
Association and the private respondent.
Yes, sir.
Mr. R. Sinha, learned counsel for the respondents number 7 to 24. Submits that he requires further 2 weeks time,
3 weeks, Your Lordship.
3 weeks time to file this counter affidavit. It is submitted that since the respondents are employed across the state, further time is necessary. Mr. B.P. Bora, learned counsel for the petitioner, submits that. In spite of opportunities being granted, affidavit has not been filed. Meanwhile, government, you filed,
Yes, I
you have not filed.
Not actually because these petitions there were earlier round of litigation also.
Mr. B.P. Bora, learned government counsel appearing, the learned counsel appearing for the Department of Health, makes a similar prayer for time filing affidavits. This after 4 weeks. After 4 weeks, let them file. Why fix a date after 4 weeks? Let it-
Item number 24.
Your Lordship. Your Lordship, my matter may be. Also for the.
Why? Why?
Put some personal, your back document in your. Everything to know that.
Who is the senior counsel?
PM data. PM data.
PM Decca. Where, what is the writ petition number?
I am not approving record.
You are mentioning on which matter you are mentioning?
24.
PM the current.
Huh?
PM the current. Last quarter was the PM the current.
At the request of Mr. What is your name? R. Ahmed. Making mention on behalf of Mr. B.M. Decca, matter status passed over for the day. Mr. Soma. CKS Borwa, PSPT. Respondents. Wonderful. Passed over.
25.
after the petitioners, the teaching and non-teaching staff, one photograph institute, which is the military type of institute in the northeast Europe. And they were appointed way back after the establishment in the year 2010.
Some affidavit is filed. Do you want to file your response?
It is not required. It is not required.
Not required. Okay.
So at the time of appointment and since the date of their appointment, they are getting a facility as per the ROP 2009. That was in existence at that point of time. In the meantime, the government has already set up a trade commission, 7th trade commission, completed its report, and the new ROP,
You are appointed under which department?
Ministry of Tourism,
As
as the assistant lecturer in the Foodcraft Institute. And some of them are other employees of Ocean Health. Laboratory assistant and peon also. I have given a detail at page number 9. The designation. They were getting the ROP 2009, but when the ROP 2017 came into existence, they were not given the benefits. So when they made a representation about it, and in this available of investment said that there was some delay in not giving the proposal at the right point of time, so it was missed out. In the next time they will consider. Which is there in the availability about it, filed by both the Ministry of Tourism as well as the Finance Department. It's taking the stand that during the course of the proceeding that was going on, the proposal was not submitted and therefore it was not taken into consideration. Worship takes up first the affidavit of Ministry of Tourism at page number 17.
yes.
Page number 71, you should find at paragraph number 4. That with regard to the statement made in paragraph 13 of the repetition, that department stated that a representation dated 12/11/2018, requesting for 7 state commission, and permanent grant from the state government, from the principal group of FCI Samagul Nagav, that this department has been to finance department for the concurrent matter, and the state has been declared by the finance department, which has advised as tourism department is advised to make the proper submission at the time of start of next mechanism adopted by the government for fair revision of whatever declaration mechanisms the government put in place in due course of time. Accordingly, the matter was informed to the Foodcraft Institute. Then the finance department also submitted an affidavit. It starts from page 75 to the same standard.
What is that mechanism, Mr. Orbuzari? There's some reference to
Yes, whereas, yeah, I already looked my benefits and then I already parted into particular state. This is proposed to be granted to any class of employees that might have the concerned administrative department, whether we have to move the appropriate proposal at the time of constitution of the state commission, because state commissions are constituted periodically. After every 5 years.
Is it your case that people belonging, people in this pay ban has not been given the benefit, or the benefit given to this pay ban is not applicable unless proposal is moved?
Yes, that is the difference, but there are specific in the repetition. The matter comes to take 50 matter.
So what is the job of the anomalous committee then?
Economic committee once the information matter recommendation, then matter the economic committee speaks matter for matter regulation of the design arising out of recommendation. For example, matter the commission gets a recommendation matter for application of any pay, matter any some persons are.
Who is to forward the proposal?
But there is a concern administrative department, that is matter, but we is tourism department.
So tourism must have forwarded the proposal.
After the state commission was during oxygen, it made recommendations, economic, everything was over. Only thereafter they.
Who is for the tourism department? You are very for the tourism department.
We just specifically taken a specific and at the impact manner, the concern acknowledgement on the government side. Let's just be annexed to the activity matter. At page 79. Page 79 manner. 379, and this is the rejection, madam. And I'm reading it, madam. Tourism Department, your endorsement dated 15/7/2019. Finance Department observed that three commissions constituted by the government that periodic intervals provides enough evidence for various services and matters to represent their demands before such three commissions. Once the report of the three commissions in the form of recommendations are submitted to the government, the same is examined and placed before the cabinet for approval. This examination at the level of the government is done to ensure that all concerns and demands of various stakeholders are adequately addressed. After publication of ROP, the existing mechanism provides another opportunity for redressal of any judgment defect for anomaly committee. Again,
When was the next pay commission after that?
where the next is because it was done in the year 2017.
Oh, 17 pay commission.
This is the latest. And madam, I will read it further, madam. Against it, the finance department observed that there has been no such recommendation of seven. Some pay and productivity commission, as well as anomaly committee for allowing invoice state case. As per some decision of 2017, to the employees of Food Craft Institute, Samuguri, Finance Department reiterates the proposal regarding extending device pay scale as per ROP rules to the employees of Food Craft Institute, Samuguri. As such, Tourism Department is advised to make a proper submission at the time of start of next mechanism adopted by government for pay revision or whatever dedicated mechanism that government puts in place in due course of time. But here,
Yes,
This cannot be a project, valid on this, they are the employees of the concerned department. It is for the department to take up the proposal.
right, they have not taken up. They did not take up. Now what is to be done?
But subsequently, since the matter has been brought in regarding this anomaly, they were achieved. When the report of the committee constitutes to examine the report of Assam 77, this committee has given an observation about it. A project has this book of draft of service.
You show us from there. Your pay scale is referred there.
My pay scale is not referred there, but if somebody's list of what is to be done, that is being provided in this.
What is it there?
Narrative. Recommendations from
Assam pay, revision of pay.
this provided that inclusion of designated and debtor posts in ROP. The committee is of the view that all steps will be taken to improve all earlier debtor posts in ROP. However, this is subject to submission of all related information documents by the department. Due to time constraint, ROP in its earlier form will be issued first. On submission of the requisite information by the department, necessary actions will be taken and all debtor posts will be included in the ROP by way of notification. So if some posts are left out, and then it comes to the knowledge about it, the same can be done by way of notification.
Yes,
This is a case where
Mr. Borpuzari.
so now my lord, the anomaly committee is that everything is my lord, now contract of the year. And hospital kindly see my lord, that 879 I have just now required. My lord, their endorsement, their proposal was moved my lord on 16.
We are not disputing your contentions, but there is a provision under the rules itself. You take the necessary steps required.
That states my lord, now it has become.
You check the rules and say that these rules are also not applicable.
Otherwise, also, my lord, hospital kindly appreciate, there is a case for us where they are not regular government employees. They are employees under a society. But nonetheless, my lord, for some reason, they have been, my lord, given a pay scale. And that pay scale also will kindly say, my lord, nowhere in the, there is no material available on record to show, my lord, the compliance of the finance department was taken, my lord. For extending the benefit of, my lord.
But that is not your ground for rejection.
That is not our-
Then you will have to examine this and make a statement.
There, my lord, that is the.
You look into the rules and tell us, the rules are precisely for that. Rules 9. Let us follow the precision follow them. Huh? Let us sound at a lively kind of novel. The cheated are little.
This is not regard to extension of base granting in my tender responsibility. This is with regard to inclusion of depth of post or redefinition of post. I am reading it well. But inclusion of redesignated and depth of post in ROP. The committee is of the view that all steps will be taken to include all other depth of post in ROP. However, this is subject to submission of all related information documents by the department. Due to time constraint, ROP in its earlier form will be issued first. On submission of the requisite information by the department, next action will be taken and depth of post will be included in ROP by way of notification. Now, there is a case where they are seeking application of the base schedule. The posts are already there. I don't know why.
We are not taking upgradation, we are taking the benefits of our because.
Therefore, I need.
Yes, you file a rejoinder referring to the rules. You file your rejoinder. Mr. Ramesh Losar, Learned Council.
It's not that the citizens have somewhere got it, somewhere, some departmental negligence or some departmental inaction has resulted in this phenomenon.
That's right. You refer to the rules and file your rejoinder. Mr. Ramesh Losar, Learned Council petitioner is permitted to file a rejoinder to the affidavit filed in the correspondent number 1 and tourism department as well as the affidavit filed by the respondent number 2 in the that is the finance department. That will be listed after 2 weeks.
Items 26 to 28.
Yes. Some review petition is also there.
Actually, review is there.
Review against a review petition.
Review in respect of the judgment, my lord. It is. When the review judgment is dated. Sorry. Ah. 91.
Ordinarily, it is to be placed before the Honorable Chief Justice to decide which bench it will go after.
It is there.
After limiting.
Allocated.
I don't see any note.
Constitute Sarko has retired long back.
No, in the review petition, because perhaps it is connected with the writ petition.
Yes, arising out of the.
Notice was issued by the Honorable Judge.
Yes.
Subsequently, I don't see any notes.
In that case, why not the file will be placed before the chief justice for passing an order of the.
And what about the writ petition?
Same matter, my lord, arising out of that. No, it is correct. The repetition is in respect of the same advertisement. Now, what has happened, my lord?
Hmm.
860.
No, what I'm asking you, what we want to know is,
Yes.
can we delink the writ petition and the review petitions, or you want both the matters to be urged together?
Since the subject matter is same, it would be ideal, my lord, if the both the matters are taken together.
Then we'll have to pass that order in the, this review, item 27, 28. You right, This review petitions are directed against the order passed by the ordinate bench by judgment against the judgment and order dated so and so far. 3/3/2021 passed in WPC number 1049 of 2021, which is item 27 and 28. Order dated 3/3/2021 passed in. I think there are two.
1049 of 2021, WPC.
1049 and 1181.
Yes.
Two petitions. Review petition number 57 and 60 is directed against these judgments and order. Registry is directed to place these two review petitions before the Honorable Chief Justice on the administrative side, passing necessary orders for allocation before the appropriate bench in view of the coordinate bench who had passed the earlier order, having debited office in the meantime. WPC 4017/2021, we also listed along with active petitions.
Item 29.
There is some particular development of which I have to advertise my reputed. So one of the person in this does not also file one case. Things are figured in the case, but regarding the stage, the notice we also file one case. And in that case, I have completed as respondent. That case below that other case. I have to take transfer on that.
Mr. A. Ahmed, learned counsel for the petitioner, submits that another petition being WPC number
WPC number 4656.
4656 2020 23 has been filed where the petitioner, present petitioner has been added as a private respondent. We'd like to obtain instructions in the matter. And if both the matters be listed together. To be listed together. We listed together. Mr. So-and-so learned counsel appearing for the government will file necessary affidavit to be checked. List WPC, this period petition along with WPC so-and-so. After 2 weeks.
Item number 30.
Passover for the day. Thank you. You are praying for a Passover, you want to submit in the matter. Passover. Passover.
31.
Punishment of the petitioner. Under section 40 of the BSF Act, this is watching like a meetings are complete. Watching on this, we can read number.
All right, list for hearing on whichever, what, let it come in the part 2 list. It is submitted, the pleadings are completed by the parties. Admit matter be listed in the regular hearing list.
32.
Is nobody for the petitioner? None appears for the petitioner. None appeared for the petitioner on. You are appearing? Yes. Tell us. You want a Passover? for the day. Time being. Time being.
33,
Basically, advertisement was made in 2009 and subsequently, justice was published in 2010. And a group of the petitioners, they did this special leave and their petition has been disposed of 22/9/2019. Thereafter, you will see. Page 6, page 7, you will see. Another group your worship the staff people and their register has been disposed of on 31/5/2019. 11 pages to page 80 last year. Last page 80 last page last where I worship. In view of the current deputy is disposed of, the direction to the responder of committee to consider the fee of the petitioner for grant of similar relief. If they are found to be similarly treated as those of prescription of current law by seeking whatever they amount of transfer. And I can immediately are this can be directed to other mind.
You want your petition to be disposed of in terms of this order. Yes, anything?
Yes, Council, let me get that same data to penalty of the prayer also. Providing the respondent to adjust or appoint the petitioner to the newly created vacant post. Every must settle sorry from the budget. Consider paragraph the petitioner for the qualified in security. So let me check whether you taken the adjustment.
I am not getting of to
He is only asking
Yes.
for consideration.
consideration, but if there
If they are similarly situated, you should pass.
Yes,
in this case, you are not tracking in order.
Did you approach this court earlier? You read the order at page 79. 79. Please read the order. Second paragraph.
That will be working. Even though the other
You had approached the court.
they no they have contended that they but their name was not there.
Exactly.
But name the name was not there in the original report. The conviction
Their name were not there because of some anomalies, but they had intended to approach the court. Is this your case? You had also approached the court earlier. The- What was the order passed in 2725?
place for this start from the for this in the order.
Hmm.
The written part of the university we find that says 777. Written part. 76 the word. Respondent are directed to consider the case for appointment or any or other student both with attend the available current and not available. If they are limited considered a phase when at least all of them are considered. It is found that the petitioner in the meantime have some coverage. The owner of the system gives them in the that may be required. Clear that the owner of the system not be updated. But clear. the number of. Because the people may examine.
Hmm?
After that, you will losing water losses. Disposal. Directing.
You argue your case and tell us that you are covered, similarly situated. Why should we close the writ petition? What is the point in closing a writ petition saying that your cases will be considered? Can't you see the direction? No, no, no. See the direction at page number 75, para 30. You approach the authorities, if the authorities don't consider, that's a different issue, but what is the point in giving a direction like this without coming to a finding that you are a part of the same selection? Did you participate in the same selection? On what? Let us see your documents.
What has been 32.
Now, first tell us what is the advertisement dated?
What has been released 22/2009, 28.
So you participate in that.
Page 42.
Then any appeal against this order in the meantime? You get instructions Friday. Find out if there is any appeal against this order for review. Learned government advocate will obtain instructions as to whether the judgment and order dated 22/2/2019 passed in WPC number 2725 or 2010 has attained finality in the meantime. Matter be listed again on Friday. 28. Mr. Age, IH for me and this for the petition. 28.
Item number 34.
Yes.
Best question. You brought three pilot, 3 day pilot, working engineer minus new engineer minus, he is supposed to promote the assistant engineer minus. So they have a 30% job in pilot for the junior engineer minus. Diploma or accordingly, minus so in the next pilot, they have shown that there is a vacancy pilot. For the 30% quota of minus junior engineer. The post of excellent engineer. The my name exact pilot is 75 pilot serial number. Firstly, come to the minor. Which minor? Connection 1 page 22 minor. Connection 1 minor, this is the least minor. Here minor, my name is FPRP minor. SC number is 68 minor. STP minor. Base 25 minor.
25,
page 25, serial number 68, my lord.
68,
My lord.
yes, your STP,
My lord.
yes.
So this is the my lord gradation list, my lord, of the. Then my lord, comes the minus the meeting of the selection committee, my lord.
Yes.
They have my lord approved for promotion, my lord, recommended for promotion 18, my lord. 18% out of that, my lord. For his chief STP, my lord.
Now. This 35, 65, that is what?
My lord, 55, my lord.
No, 35, 65.
No, my lord, 30 and
Roster point,
7, my lord,
roster point 35, 65 is for STP.
my lord.
So,
No, my lord, not my lord, it is not 30 and 60, they have four post product of my lord. So this may come to them, my lord,
minus last paragraph.
my lord. My lord. My lord. This selection committee discussed about the vacancy for your extended energy diploma during 2010 found 21 long-term vacancy occurred 2021. My lord. So this is the my lord tax of the matter, my lord. They have approved 18, my lord, because of that 18. But according to their minus the meeting, they are doing 12 vacancies, my lord. Of which 14 are existing vacancies with past reservation for unreserved 2, 6, 40, 42, 52, 54, 59, 60, 60, 61. For reserve 45, 65. And this is SC for 1 and ST for 1 mile are proper vacancies which will tax sales also filled up by the in the 2021. Accordingly, my lord, they have recommended 18 miles.
So vacancies were how many? 21,
According to the my lord, 21 miles.
21.
21 miles.
So 21 into 4 zone of consideration.
My lord. If they have my lord 21, they have considered my name supposed to be within the zone of consideration. That's why my name is not my lord, then the recommended fixed my lord. They have only 18 minutes, my lord, they have only considered my lord 86, 76 vacancies, my lord. Vacancy, the second thing, 76 minus 4 times of the minus vacancy minus. Only they have considered only up to serial number 76.
So there are 14 existing and 7 probable
Minus,
future vacancies.
minus, up to 31st December minus. They have not considered up to 31st December 2021. They have considered up to November minus. They are activities from the minus public health and department minus.
Not if we have just received the instruction, we'll file it in this week and your document posts this matter any date next week.
You could have said that in the beginning,
I was speaking.
Mr.
I was,
I,
what,
Board Thakur Learned Council appearing for the public health.
Yes.
Submits that instructions have been received and affidavit in the matter will be filed shortly. Affidavit will be matter, affidavit in the matter can be filed. So Mr. M. Soronia, Learned Council for the petitioner submits that their affidavit will be necessary to reflect the number of vacancy considered by the TPC for selection for promotion to 21 numbers of vacancies. There are at a point in time. Matter be listed after 2 weeks. Yes, madam. Or tribunal. So we are appearing for which respondents?
I think
6 respondents, 6.
would not appear, madam.
Yes, MS so and so appears for respondent 6. Let them file after 2 weeks. We are giving them 2 weeks. Let us see.
Right.
Let the affidavit come.
Item 25. Can people circumstances, conducting council will be here. Kindly matter very fast. Therefore,
So and so learned counsel appearing for the, on behalf of, who is the conducting counsel?
next week.
Mr. S.P. Hussain submits that Mr. Hussain is unable to appear in court because of personal reasons. Matter 6 adjournment for the day. Matter will be listed next week. Learned counsel so and so appears for the response.
Supplementary list for admission, I think 61. Right. Hello, this is I'm telling you, constellation. Then, on advertisement was input for development of new driver, under the department of, under the profession of and the hidden regional, the regional of one. He is having an experience of more than 20 years, under the high dignitaries of the government of Assam. He started to work as a driver of some of the ministers of the government of Assam previously. So ultimately, the minister of the participated in the state, state. Then, my lord, the name of the region was shortlisted.
You are filing the writ petition on the basis of suspecting there could be some illegality.
Because I am wondering that, my lord, in a public appointment.
Yes, who's for the respondent taxation department?
They are transparent.
Which is constituted.
You have the records,
They are filed their evidence.
you produce the merit list.
Yes, ma'am.
Report.
That is what. Calamity, my lord, the test report that was done by the MBI, my lord, the skill test report that was done by the MBI, but that also contained the signature of the candidate, my lord. That also should be, my lord, for.
There is an affidavit already filed.
Already filed, my lord, by along with the evidence, in the evidence, my lord, they have not produced for an area to occupy. Leading merit list of the candidate. They have only, my lord, stated, my lord, only one letter, other than that, my lord, there is no, my lord, the record pertaining to the, my lord, marks obtained by the candidate or their merit position.
You have seen, you have, you got only 90.
They are containing.
Yes, then. On what basis do you want us to disbelieve this contention?
Because the merit position was not published before the finalization of the candidate for appointment. Secondly, what I am contending, my lord, and I am stating, because I am having more than 2 years of experience as a driver, and I have worked as a driver of highly dignitary. Even the honorable recently the signature of Assam, I used to work as a driver of the honorable minister, my lord. But my name was also short, but if the merit position was hanged, my lord, and I was confirmed about the merit position, but I would have entered it here. But what I am suspecting, there's some unfairness, my lord, happened, my lord, in the relation to this, my lord. That is why in the public appointment, my lord, everything should be there and transparent. So, my lord, the merit list, my lord, maybe also from the department. The merit list containing the, my lord, driving skill test that was done by the examiner. Only then, my lord, everything will come out. If everything is clear, I don't say anything, my lord.
Regarding whether the mark for a.
We have seen the marks. His grievance is that you did not put up a merit list before the select list was published. So
That part, well, I can have the, other than DS code apparently was 20 or 90 marks. And a serial number.
his grievance is that the skill test and the written test,
Well,
there was no merit list. What is the difference between the select list and the merit list? I mean, what is the process after written test and skill test?
My lord,
Is there any interview also?
yes, my lord, because
After-
No, it only the skill. Because my lord, in a diver pole, when the written test is of the, for that was relevant, but only the skill test is very much relevant.
So the skill test, they have produced the select list, that in itself can be treated to be the merit list.
Yes, madam. Merit is, we call them the, that the skill test because that will do.
No, have you published the select list?
No.
That's what, madam,
They are not published slightly. Including one merit position of the candidate. I mean, he may be directed to one merit list.
that, on that part, madam, the academic is silent.
Even
It
if
says,
it's-
para five says, madam, that the final selection list was prepared on the basis of merit list and rights of the people.
You find out from your
So, I final action level is all, madam, it says the selection.
you place it, that's the only thing he wants.
Well, yes.
My only grievance is that if I was wrongfully deprived from the service ballot, that will go to do the necessity. Otherwise, from the merit position, I find that I am not. I am not the right candidate, I am not.
When can you produce it?
Along the mark scored by each of the candidates, that I would guess.
When can you produce it?
Well, on Friday, madam.
Friday. List on 25th. Enabling Mr. B. Gogoi, Understanding Council, Department of Taxation, to produce the relevant records which will reflect the the merit position as well as the select list published by the respondent authorities in response to the advertisement or selection of drivers under the said department. Mr. Islam. Islam appears for the petition, list on Friday, 25th.
Hello.
Time being item number 15. Item 15.
Yes.
You are talking to the post of the LDA of the director of the medical education. Thereafter, Lordship, all of a sudden, private is only, you are promoted, you are 14 years.
This matter is to be disposed of. It is for admission hearing. This is for admission hearing. Pleadings are complete.
Your Lordship, they have to file a counter to the reply.
Who has to file?
We have to file a counter. The affidavit in reply. Filed by the petitioner.
What counter? You have filed your affidavit.
We have to file an affidavit.
Ah.
Your Lordship will see at para 5. There's the promotion.
Para 50?
Para 5 of the affidavit in reply filed by the petitioner. By this para 5, there 17 promotion order dated 11/6/2020. And also let's stated that they're 14 years senior to us, which is in fact much too given. That's why we have to file a counter. to this reply.
No, sorry, I didn't get you.
That's for para 5. That stated that they are 14 years senior to us.
Para 5 of the,
Para 5 of the affidavit in reply. Page 27. Page 27. Page 27, para 5.
there's a reply of the petitioner against the affidavit filed by the respondent number 2.
Yes.
Respondent 2.
Yes, respondent. Respondent to the department.
Reply filed against whose opposition?
Against respondent to the point. We are in that for respondent fee, but they have challenged our promotion order.
So there is no para 5 in that, there is a para 4.
There
They are secret provide specific regarding the data for that. And electronic of child completed department of it. And I have recently this person about the income some kind of. And what they have informed me that this specific instruction will be included to the inner instruction that will be provided to me. To be a complete income. So the weeks and rate.
So we had given 2 weeks, we had given 2 weeks time, earlier council was there.
Actually,
I ordered it 29/5/2015, it's a high court order, page
it's
66.
not required to be disposed of.
You will also kindly pay the connection and
Please.
page 66, connection and second last paragraph. May I read?
Yes,
Accordingly, we are concerned and agreement of the parties, this replacement is disposed of within a direction to the commissioner secretary to the governor Assam Senior Department to dispose of the petition as affiliated 24/8/2012 within a period of 1 month from the date of receipt of the certificate copy of this.
this is whose appeal,
That it is.
preferred by whom?
Probably, as per my,
Basically, it's for.
what are your document directed to?
We have directed to find out what is the status of the appeal and what happened to the,
Though
Order.
1 month, they decided to within 1 month, right?
you are not in contempt before the against this court, and in any case, this writ petition was not filed by you.
We have filed contempt case also, my lord.
Ah.
Interesting, my lord, same contempt case number, my lord. One Sumita Devi has been got appointed. Even in her appointment order, that contempt case number was reflected. Which contempt case was filed by me?
All right, let him get these instructions.
Right.
You get it within 1 week. Enough time has been granted. And we make it clear that in case you are not available, somebody else is there, instructions are not here, we will personally call the director.
Basically, senior, only the particular is.
We don't know that. You can't expect a court to be begging for instructions.
Oh, I understand.
Then,
I'll get it.
Your lordship has also person specific instructions to provide, my lord.
heard, that is
Yes,
counsel for the
order
parties.
35.
Yes, kindly listen to the order, heard that, done it counsels for the parties. In spite of the earlier order dated 31/07/2023, directing, permitting the additional senior government advocate to obtain specific instructions in the matter. Which was to be furnished by the Director of Social Welfare, Assam, in respect of an appeal filed by the private respondent and the status thereof, woman. No instructions have been forthcoming as submitted by Mr. So-and-so learned counsel appearing for the government advocate, appearing for the respondents. So only in the interest of justice, we grant further 2 weeks time as prayed for. And on which pursuant to which the instructions as directed be placed before the court. Failing which, the court will consider directing personal appearance of the Director of Social Welfare. Assam.
As directed, idea was also reflected.
Not necessary,
31/7.
not necessary.
May I-
Let the matter be listed again on 15th of September.
Timing item number 30.
I, but some of the workers of the we were workers of the ACT there. But in the legal provision providing that the emoluments and the benefits cannot be less favorable than the state. What remains will be there, but now the state has given some benefits to its employees, which was earlier followed by the PDCL. But now the same has not been given to the petitioner. Now in this matter, all pleadings are complete. This is the second round of litigation.
or at least for admission hearing. Give or take. It is submitted by learned counsels that pleadings are completed in the matter, is for admission hearing on
18th.
18th September.
Timing item 36.
In this matter, whatever you got to the directed up to find the epidemic. Our epidemic is ready. The content epidemic is to find the epidemic. So we know the views are there. May we let this matter be come up with Friday. Otherwise, we are ready.
Is the department closed? Because of the leave of the engineer, is the department non-functional? Ah. So you'll find a substitute officer who will file the affidavit by Friday.
So today the concern engineer will join.
Ah. So very well, then get the affidavit by Friday. Mr. Das, Learned Standing Counsel, NC Hills submits that the affidavit will be filed on behalf of the department within the course of the week. Mr. D. Borua for the petitioner, matter be listed after 1 week. We have recorded his submission.
43.
After
Item number 43.
where is MS Army Bora? What are we supposed to do till then? What are we supposed to do till then? Please call.
Look, what I find is that the order of this honorable board has been presently, no,
Where, what is the direction of the court?
direction was very specific, I think, come to page 11.
Yes,
Nothing more was asked to done. Simple thing they would have done it from back. Well, paragraph 9 starts. But 11th line, it will not kindly come to, the only impediment is giving appointment.
yes,
The only impediment in giving appointment to the commissioner was that no approval has been taken from the finance department by the Minister. Here we have the procedure laid down by the OM with the 23. The principal secretary of the district is directed to give prior approval, kindly look into it, take note of it. To give prior approval for filling up one or all three vacant posts of their board that existed in the year 2010 to be filled up by the petitioner. And send the same proposal to the finance department. The finance department shall thereafter give its approval for the same and respond that authority shall pass the orders for appointing the petitioner as per the approval given by the PTC. This should be done within 3 months. Now, what prevented the authority from giving prior approval? Judicial authority,
yes.
every time what you will see,
BTC authorities, yes. What is your instruction?
Now I am actually for authority, but it's no longer critical. Present is no longer. But in the meantime, I think it's already is getting for a case.
No. The direction of the court is to give prior approval.
yes,
Has it been done or not? You see the direction, page 11?
But also, in case of
This is a contempt petition. Directing the file alleging willful and deliberate violation of the direction of the court by order dated 3/11/2017. There is a specific direction in para 9.
I will approve here normal step proceed, but this case is then for the assembly. Proceed, but I am cannot apply. Yes, for that person.
Is this copy of order not available with you?
For that, I don't know whom I have represented is no longer in office.
He may not be in office, but if he has violated the contempt order, where is he gone?
It's now election.
So we'll have to call him from his office of election commissioner if we find that he is violated. His demeaning office will not absolve him from violation of the court's order.
But that's for professional, but it's for as per.
That instructions must be relevant to the order which you are required to comply with. You can't just throw any instructions before the court.
Approval is what is called, the approval from the finance department.
You have not read your instructions. Pass a copy. Or better you share your instructions with Mr. Mohanto. Do you have a copy? It is a letter seeking legal opinion. This is not instruction, this is a letter seeking legal opinion.
They have already placed the letter part of kindly see last page.
You see the last line, we are not reading it out.
Last page, you already placed for years, same. DLC minus 15 and along with DLC.
You,
Already placed for years.
If the board, as I find it, the board is responsible. There's a direction to give only approval because that was already done. That part being approved by the authority for official appointment and it will be ordered. The order of this.
you read the last paragraph, madam. Last paragraph of the,
Already placed for it.
kindly read the last paragraph of the covering letter. They are asking you for an opinion.
Already placed for DLC.
Is this the direction of the court to place it before DLC? What is the direction of the court? Direction of the court is not to place it before DLC. Para 9. Do you understand the meaning of a contempt proceedings? This order either has to be complied with, or you tell us that you have filed a review or an appeal against this order. Or you tell us this order cannot be complied with because of whatever reasons are there. Is there a senior standing counsel? Who is he? Well, please send information. We need to find out. We are not, you are unable to assist the court here. The direction of the court is to give an approval. Whether you should follow the compassionate appointment procedure or not is a decision you have to take. This order is very categorical. You get your instructions, we'll take it up on Wednesday. We are giving them one more chance. If you want to share your instructions, you can show it to Mr. Mondo.
Despite this 5 years, they are not clear about it.
If she is generous enough to share the instructions with you, you will realize why I'm fixing it on Wednesday.
But they are not aware about the fact of it.
You are,
But you will forget that part.
no, newly impleted is okay, but the earlier person who's already impleted cannot wipe his hands and say, I have debited office. He'll have to be called to explain why he did not comply with the order. You please get your instructions by Wednesday. Whether the paragraph 9 has been complied with or not. All right? We will let the matter be listed on Wednesday, 23rd for orders. For orders. Enabling the learned standing council BTC to place specific instructions as to whether the direction of the court passed by the order dated 3/1/2017 passed in WTC 2435 of 2011 has been carried out, has been complied with.
311.
Sorry, 3/11/2017 carried out. List again on 23rd.
Item 44.
What is the direction here?
Directed the director of illegal assembly and Senate department to raise the application of the petition for the
It has been done. Has it been done?
in a certain thing on the petition of the leader, I am not the director, I am the one the simply the independent party.
Who is the director?
No, I am not one. Pulling from the.
No, you are now what?
I am already retired and at that particular time I was deputy director.
Oh, you are already retired.
Yes.
None appears for the petitioner on call. Mr. E. Sharma, learned counsel, and enters appearance has appeared on behalf of respondent number, sole respondent. So it is submitted by Mr. Sharma that in terms of the direction of this court by order dated 6/12/2017 passed in WPC 7521. The Director of Animal Husbandry and Veterinary Department, Kailipara, was required to place the application of the petitioner for compassionate appointment dated 1/2/2017 before the next available DLC of the Boxar district. So, the council for the respondent submits that at the relevant point in time, he was holding office as the deputy director in Boxar.
No, the deputy director, animal husbandry and
He was holding office as deputy director, animal husbandry, veterinary department, government of Assam, Kailipara. Where is it? Kailipara, Khanapara, Guwahati. Stop. he submits that who was the director?
That's what is the Pulim Chandra Das.
One Mr. Puling Chandra Das was the person who was holding office of the director at the relevant point in time. So the sole respondent has in the meantime superannuated. Do you remember the date?
March 2020.
20. Superannuated from office in March 2020. Stop. He therefore submits that the direction of the court is to the Director of Animal Husbandry and Veterinary Department, Kairipara, and not to the sole respondent. Stop. He was wrongly included by the petitioner as the sole respondent. Stop. However, in the absence of the petitioner, matter stands adjourned for 1 week. For passing destiny also.
Item 45.
Some and due. Out of that, I bought 6 lakh. What is outstanding for MF? 11 lakhs. 10,000. 90 rupees cost. Hardship, the police not with everyone. And me, I have going on. One of the different words. We lost this life also. Because of one of the different. The country also is everyone also. You as a papa, you will be very much. Now there is article to come. Because of medical consent, we get given. The balance is 11 lakh 50,000 euro. Within a month of 2 weeks, which need after a period of 1.5 months. So that my lord, you can read the latest. What's my country? Yeah, at least for my digital direction of these two big, at least 5 lakh issues. I have to go, yes, yes, also, post separation. Also, this Krishna, yes.
You release him 5 lakhs to be realized, to be adjusted with his final payments.
I don't, for that, I think it's section. But they can approach, medical ground, money that they want to the money is disbursement. Launch already.
Medical ground money is disbursed to employees, he's retired.
The entire investment.
Okay.
They must take, department with something. Also, already I have submitted the application. Nothing is paid after their cost. So, because of the dilated action of money, they did file it, that action.
This is a contempt petition.
What I then I'll see.
When are you receiving the?
I told him I don't after that it's 1 month, but maybe some here and there, 1.5 months. Also, this order passed by the code on who will get the budget anything product is on one side at that time. The respondent under to get payment of their work. Order is very clear. Pays investment of we have paid substantial amount by law. On the 21/4/2018, 6 lakh something.
Learned counsels for the parties. Mr. J. Roy, learned senior counsel, appearing on the ASTC submits that the total amount payable to the petitioner is 11 lakhs.
11 lakh, 60,090.
66,090.
Thanks.
66090. Towards his retirement benefits and leave salary.
My lord, gratuity, 8 lakh something like 21,000. Then early 1 lakh and CPF 2,44,500.
Gratuity, earned leave, CPF. Stop. And other emoluments, stop. It is submitted that the budget for the same amount has been budget proposal for the same amount has been submitted before the appropriate department in the government, and the same is likely to be received by the department within a period of 1 month from today. 1 month. Stop. He therefore submits that the matter be taken up again after 4 weeks, so that the status of the payments required to be released to the petitioner can be placed before the court. Stop. It is further submitted. In the meantime, petitioner has been released how much money?
So let him buy immediately.
No, you have released, what is the amount we have released?
Madam, we have 6 lakhs of amount. 6,000,300.
He has released 6 lakhs,
58,300.
58,300
6 lakhs, 7,390.
has been released by the petition, has been released as per the petitioner, whereas according to the respondent, the amount released is 6 lakhs,
67,390.
67,390. Stop.
398.
398. Stop. Mr. R. Sarma, learned counsel for the petitioner, submits that at least an amount of rupees 5 lakhs required for medical treatment or to be released by the department. So it is submitted by Mr. Roy that the petitioner may file an appropriate application before the MD, ASTC, requesting for release of the amount for medical treatment. So accordingly, let the matter be listed after 4 weeks. Meanwhile, the petitioner is permitted to file the application seeking application praying for release of amount for medical treatment before the MD. Matter be listed again on 25th of September. 25th September. You can file the application before the MD.
46.
Yes, Mr. Bora.
So, number 1, let us know as my evidence during while you're serving. I would say 4 of the 5. But in the meantime, all the contractors named, they have been noticed on in as part of the surveillance. But affidavit in several things we learned. 1 has already filed by the service, and 4 also have filed. Now, we have filed reply also to that affidavit regarding.
What is the order 8/2/2018?
Page 9.
Page 9. Second last paragraph. You are required to place it.
That's it. We have already done that also.
Where
It can be closed also.
where is that statement?
That's it. In my activity page 2. Paragraph 4.
You have been. We have filed reply, you can get up.
Which seat?
That's it. It was filed on object 15.
Filed by respondent 2.
That's one number 1. File on object 18/12/2019. Kumar Sanjay Krishna.
Yes.
All right.
Paragraph.
Paragraph object 4.
Placed before SLC.
Object because the place object it was reflected because of delay in submission of the application object. And that was also communicated to him also.
It was to be decided below. That is to be decided. You can find counter to that ability. Because that if we go by dates below, we'll see this particular information I have denied that I have not received that same information. Even below, if we go by there is evidence filed by number 2. There is number 2, my lord. they have stated.
It is pertaining to the SLC.
And moreover, my lord, that is to be here, one point is to be decided, my lord. Is they did not file affidavit in opposition in petition. But now they want to improve the case by filing in contempt petition, which cannot be.
Who has filed contempt petition?
I have filed contempt petition.
You have filed contempt for non-compliance of the order dated
Not
8/2.
compliance of the order too. But already this order got submitted, then I have filed contempt, I reply, my lord, to that point.
You may have filed reply, but the contempt petition is to find out why the order was not complied with.
Not comply.
The
But
direction
that
of the
is-
direction in the order,
Definitely,
direction in the order is to place it before SLC
SLC,
in the next meeting.
next meeting. Next meeting, will not date the lordship see. They, according to them, your order was there, you either place before the SLC or if it is filed, if you already place inform the petitioner.
Within 4 months.
Forwards, but that is the day they are giving information, which is third parties, they are showing that it has been filed. Their second part, they are trying to show me that this already we have communicated. In reply, we have said, it is not been served to me, we are not aware about that.
Where is the minutes?
My notes, I don't, that has not been enforced, okay?
Yes.
But the fact remains, okay? Because he had submitted the application date, that was already decided on the.
Later on, we know.
The question is, you have to place it within 4 months.
Not a reason, first.
Uh,
In view of the SLC is directed to consider the case of the petitioner. In its next meeting for confession and appointment, provided the same has not been done earlier. It was already done.
It was already done. Now, if it was done, then you have to communicate with
But
the,
that was communicated to
It
him.
was not communicated.
how?
Lots of see the enclosure also. Page 6 and 7 also.
So paragraph 6. You say it has been complied with.
Also,
This letter, how was it sent? 10/4/2018. He says he has not received it.
Consequence, he address logic, he says that, let me complete. He says that it was his, and we have given it in the address he had given in the logic, in his case is logic. Consequence, the address given in his read logic. The read, whatever address was given, we have communicated to that address. It was Bhaskar Bora, son of Mrs. Kunja Bora.
How have you communicated? How have you communicated?
But by post, usually it goes by post.
So if it is by post, by registered post? No,
That I cannot say.
no, what we are asking you is that you have made a statement saying that it has been communicated. Now, communication has to be in the correct address. Correct address according to you is the address which is given in the writ petition. Now, whether it was delivered or it has come back or it has gone to some other address, that information.
I am told that has come back and according to them, he has received it.
There has to be specific instructions here. But in any view of the matter, the fact remains that your case was already considered.
That is why I am, this way, I have confirmed this matter, why I have to file an insolvency. Lordship may in their own letter, how this contradict, Lordship. Lordship, whatever he annexed, Lordship only by my humble submission to go to page, annex 1 page 53. Lordship.
Of
It is filed by, it is affidavit of policy filed by Kumar Chandra Krishna.
annexure 1
That is A.
A.
A. Lordship is getting. Lordship, short time I have made it.
Hmm.
We refer, sir, we refer to something above. I am directed to inform you that your name was not recommended by state level committee meeting held on 4/5/2010 due to late submission of the election. Fine. Next letter. Next letter.
Hmm.
Second time you will do. Again, he has written letter me 17/12/2019. Same communication, how it is coming, Lordship. Letter number so and so, Lordship, we get it now. Letter number, it is here not, okay. In continuation of the department's earlier letter under reference, I am directed to inform you that your name was not recommended by state level committee. Meeting held on 25/2011 due to late submission. There it was 4/5/2000. Now here it is coming to 25/2000. Simply, when they have come to know, because neither one is fact. That is why they have written. In this connection, it is to be mentioned that the meeting state level committee was held on 25/2021, not on 4/5/2007, as inadvertently mentioned. One officer, how they are committing mistake, your lordship. It is purely they are making the story only for to avoid the contempt of court. An officer, responsible officer, can they write like this letter? Oh, no, 25/2000 not now 4/5/2001. Is it the way? This is there itself, it is a doubt, Miller. They have not now sent this letter.
When was your case considered by the DLC?
DLC lordship, now this is my supporting letter will be another affidavit. Lordship will get by so number 2 Miller.
Yes.
Here, lordship made it very small. It will go good. I have officer to and so. Here, last page is exactly your lordship will get it now. Now I try to read for. Here your lordship will get last page. The letter was sent on 4/5/2002 by so and so to civil secretary Dr. Vattam, forwarding minutes of district level committee GLC meeting held on 28/2018 for appointment of this one. This one so and so date of is showing 28/2018 below. Now later you see. Now later we see here. According to them, before SLC, before DLC, SLC has decided on 4/5, if we assume it 4/5/2018 or
Yeah, Mr.
there is doubt in that, purely doubt. Only to avoid use, they should not be on a good court, purely mistaken of this matter.
What's it, whether he is entitled or
That will let us come, Lord.
whether he is entitled already, also he has delayed in filing his application.
That's not the issue. The direction is to place it before SLC or give him a copy of the order if not already considered.
What's it?
Now the communication pointed out by Mr. Borua.
What's it? That I do not have here file.
I have my, I have given a copy, you have given a copy, how can I? I give now.
For respondent to please.
Two is something, I am giving for one also. But it is, I am not.
But respondent to who's appearing?
I learned it.
You don't serve copies to correspondents. I think as per High Court rules, whatever pleadings you file, you have to serve it to all. Anyway, there appears to be some.
Recommendation of 2018.
2018. And as per the
SLC was 4/5/18.
There was set up board, I get it. Did I convert it to 7? after approval, he is saying the DLC so and so date, and we are sending a 490 to them. That before that day, I can manage.
That is the next sentence.
Mr. Bhagavati, I think there is some,
Annexer A is wrong, that I have admitted also.
Huh?
Annexer A also. Lordship,
of your affidavit.
Lordship. The dates given is. Dates given.
All right, annexure A is wrong. Then, where is your affidavit? All right, annexure A is 10th of April. Is that what you say?
It was decided, I think, what had happened, Lordship, it was decided once earlier. Earlier, it was decided once by the DLC. Because the matter is of course. 2000, the person died on 2005. Lordship.
Who died?
Lordship, the petitioner's
Father.
Lordship.
Father.
He died in 2005.
No.
And the DLC cannot be left for that long, Lordship. Maybe that was placed for the second time, Lordship.
I cannot know, but you then brought, I
DLC matter came, the DLC, they are stating now, Lordship, maybe the second DLC, Lordship.
Yeah.
How it had gone there, that I am not aware of.
that you supposed to have, you are appearing after contempt. Now, I don't think it is mistake.
No, Mr. Borua, if you come back to the order again, page 9.
Right?
Of the writ petition, of the contempt petition. Page 9. The order which you claim has not been complied with. Order dated 8/2/2018, second page. If you come to the second paragraph, you will find the date of recommendation for compassionate appointment by DLC is 3/8. No, page 9, which is the second page of the order.
In view of the consent part.
Yes.
Or the letter number so and so. I did, may, say like,
What's it?
let's say by the way, so that we go with the question account to do what they can. Say it makes them, subsequent guidance.
So this was the first DLC which recommended you.
That we now. We have to go to the if the calling and on and already reached over there by placing inside there, we need to use or use that. Now each order, ending will be applicable. Ending will be applicable.
Finding cannot be made applicable without correlation with the other paragraphs in the order. So the court directed placing of your application approved by the DLC on 3/8/2018 before the SLC, if not already considered earlier, within a period of 4 months. So the DLC recommended in your favor on 3/8/2010.
By their affidavit will.
Their affidavit is one aspect, but what we want to say is the court itself recorded that your DLC approval or recommendation was on 3/8/2010. And they say that it was rejected by the SLC on 4/5/2010, subsequently corrected to 25/2/2011. And the affidavit of the respondent 2 reflects that perhaps your case was considered for a second time and DLC had recommended, it has gone to the SLC.
Right, report is brought, this report is brought.
We are not hearing the matter, we are hearing the issue whether the order has been complied with or not. Whether we should invoke our contempt jurisdiction or not.
Just because.
And kindly come to the beginning of that paragraph itself. It is a consent order. You agree? in view of the consent of the parties.
Yes, it's like, because the order, we are not against this order, my lord. Against this order, we are happy,
You're only,
but they are
on,
under
you can of course say that you are not the council who gave the consent.
When contact also this first council, I was not there. Yes, he planned to be. Yes.
So we will close it, but-
My humble prayer,
uh,
your lordship closing, it is lordship because contact. I cannot say also not to close, the system not to present. But question is coming, because we have to take into consideration of the honor to affidavit also. And their own letter also, because if the, there seems to be doubt whether they have complied or not.
that doubt will require reconsideration of this order.
Yes, my lord.
That reconsideration, if you want, you file a review, or you go in.
I not go for that. If you, some protection if I get, because I'm gonna doubt, that is, I'm leaving to not get now. Because closure partition.
Heard learned counsels for the parties, this contempt petition is filed, alleging willful disobedience of the directions of the court passing order dated 8/2/2018 in WPC 5745 of 2014. The this, by the said order, this court directed, disposed of the writ petition with the following direction. Page number 9, you start from the, extract from the second paragraph. In view of the consent of the parties. Para learned counsel for the petitioner submits that in spite of specific directions by the court, the order was not complied with, and therefore the contempt petition has been filed. Para. The respondent number 1 and 2 have filed their affidavits. Stop. From perusal of the affidavits filed by respondent 1, it is seen that the case of the petitioner, after being recommended by the DLC, was placed before the SLC, and the SLC had considered the case on 25/02/2011, but the same was rejected due to late submission of the application. Stop. It is further submitted that a copy of the same that this intimation was furnished to the petitioner in terms of the directions of this court at the address reflected in the writ petition. Stop. Para. The affidavit of the respondent number 2 reflects that the case of the petitioner was considered by DLC on 20/08/2018 for the year 2017-18. And thereafter the same was forwarded by the Deputy Commissioner Sibsagar by communication dated 29/08/2018 to the Commandant 1st AP Battalion Ligiri Pukuri Nazira Sibsagar, which was subsequently forwarded along with the minutes of the DLC and the applications to the Assistant Inspector General of Police within bracket W and S on 30/08/2018. Stop. The Assistant Inspector General of Police within bracket W and S forwarded the same to the Additional Secretary to the Government of Assam Home within bracket A Department for approval before the state level selection committee. The same was forwarded to the Additional Secretary to the Government of Assam Home A Department on 04/09/2018 for approval of the state level committee. Stop. However, whether the state level committee had approved the same proposal was not received by the department at the time of filing the affidavit. Well, Mr. Borua, learned counsel for the petitioner, submits that there is a conflict between the statements made by the respondent 1 and 2. While the respondent 1 had stated that the the proposal of the petitioner was considered by the SLC by its meeting held on 25/2/2011 and thereby rejected the proposal, the petitioner. The affidavit filed by the R2 reflects that the DLC had recommended the case of the petitioner on 2008/2018. Stop. Under such circumstances, the statements made by both R1 and 2 are contradicting each other in as much as the SLC could not have rejected the case of the petitioner on 25/2/2018 when the DLC had considered the case of the petitioner on 2008/2018. Stop. In view of such submissions being made at the bar, the on such submissions made by the bar, the order dated 8/2/2018 passed in WBC 5745/2014 needs to be carefully perused. Stop. Upon due perusal, it is seen that in the said order itself, there is a reference of the letter number so and so dated 3/8/2018, stated to have been issued by the Deputy Commissioner Sibsagar, showing that the petitioner has been recommended for compassionate appointment to the post of UB constables, and a request has been made to place the proposal before SLC for consideration. So, the said order, as it appears, was passed in view of the consent arrived at between the parties. So, from a bare perusal of this order of the coordinate bench, it appears that the petitioner's case was initially considered by the DLC on 03/08/2010. Was considered, and the same consideration and the same position was communicated by the Deputy Commissioner Sibsagar by his letter dated 03/08/2010. Whereby, from a careful perusal of the order dated so and so, it appears that the case of the petitioner was considered by the DLC earlier and recommended for compassionate appointment to the post of UB constables. Stop. This position was communicated by the Deputy Commissioner Sibsagar by his communication dated 08/03/2010. Communication number so and so dated 03/08/2010. Stop. Under such circumstances, this court closed the writ petition directing the SLC to consider the case of the petitioner in its next meeting, provided the same was not done earlier. Stop. If the petitioner's application had already been considered earlier, the coordinate bench further directed that if the petitioner's application for compassionate appointment was considered earlier, the result of the same would be communicated to the petitioner by the Commissioner and Secretary, Government of Assam, Department of Home. Stop. Upon careful perusal of the pleadings on record and upon hearing the learned counsels for the parties, it is evident, it is clear that the case of the petitioner was recommended by a DLC and which communication and which position was communicated by the deputy commissioner by communication dated 03/08/2010. And this court directed the consideration of the petitioner's case by the SLC, if not already considered earlier. Stop. In the event of the petitioner's case being considered, the result of the same was directed to be communicated. Stop. Under such circumstances, it has to be accepted that the petitioner's case was placed before the was considered by the SLC on 25/2/2011 and subsequent and thereby rejected the proposal for compassionate appointment insofar as the petitioner is concerned. Stop. The statements made in the averments made in the affidavit of the R2 will have to be accepted to be that subsequently the petitioner's case was again considered by the DLC on 2008/2018 and recommended for the post of Constable UB. Stop. This recommendation was forwarded to the SLC as far back as 4/9/2018. And the result of the meeting of the SLC is not reflected in any of the pleadings. So, under such circumstances, this court is of the view that since the directions contained in the order dated so and so date, passed in WPC so and so, has been found to be complied with, no case for contempt is made out and the contempt petition can be closed. However, in view of the statements made by the respondent number 2 that the DLC recommended the case of the petitioner for appointment on compassionate ground for appointment as UB constable by its meeting held on 2008/2018, and the said minutes have been and the said proposal along with the minutes have been communicated to the SLC as far back as 04/09/2018. This court in the peculiar facts and circumstances of the case considers it appropriate to direct the respondents. But they are no longer there. To permit the petitioner to file necessary application before the Chief Secretary, State of Assam, seeking a copy of the minutes of the SLC held in respect of the petitioner pursuant to the DLC meeting dated. Now we do what thing. We in view of the submissions made and in view of this order, we find there's no contempt petition stands closed. Liberty is granted to the petitioner to file necessary application before Chief Secretary, seeking the result of the SLC minutes insofar as the proposal of the petitioner is concerned, which is stated to have been sent by by communication dated communication dated 4/9/2018. To the Additional Secretary Government of Assam, Home A Department, by from the Office of the Assistant Inspector of General, Inspector General of Police within bracket WNS, Government of Assam. Content petition accordingly stands closed in terms of the above. Notices issued, recall.
Item 47.
But is it available here? Let it come. It is submitted by Mr. S.R. Burwa. S.R. Burwa. For the respondent number 6, that the affidavit on behalf of respondent 6 has been filed today during the course of the day, and a copy thereof has been served on the council for the petition. Stop. Accordingly, let the matter be listed next week. Next week, 3-0. Listed on 3-0. Registry to trace out the affidavit stated to have been filed by the respondent number 6 and connected to the case report. Mr. J. Dekha appears for the petitioner.
48.
Not feeling well, we have to leave the someone. Who is going to be guaranteed?
Who is not feeling well?
R.
Mazumdar. He is not feeling well. He is submitted by Mr. Sharma.
Yes, ma'am.
You Sharma on behalf submitted that Mr. R. Mazumdar, Learned Counsel, appearing for R1, is indisposed and the matter be listed next week. Next week, we listed after 2 weeks. List accordingly. After 2 weeks.
49.
PWD, who's there for PWD? Madam can appear. They are not here, so you are a government advocate. Yes, there is an order of this court by the order dated 6/5/2019. There is a direction to consider the case of the petitioner to be placed before SLC. You can just get the information whether it was done. We will request the court master to furnish you with a copy of this order at least. None appears for the parties for the petitioner on call. None has appeared for the respondents also. Since MS Bhattacharjee, learned addition of senior government, was present in court, the court has requested her to appear in the matter and obtain the instructions regarding the compliance of the directions of this court by order dated 6/5/2019, passed in WPC 2858 of 2019. Stop. Learned government, additional senior government advocate will apprise the court on the next date fixed whether the directions issued by this court directing the matter to be placed before the SLC for reconsideration of the petitioner's proposal for appointment under die-in harness scheme to any grade 4 post under the PWD department for one has been carried out in the meantime. Stop. Copy of the order dated so and so passed in WPC so and so will be furnished to the learned government advocate by the court master. Matter be listed again on 8th of September. 8th of September. Name of MS Bhattacharya be reflected in the respondents, for the respondents by the registry in the cause list.
Madam Secretary,
Name of so and so reflected in the cause list by the registry. Same order. This is another matter where none appears and the order of 6/2/2020 passed in writ appeal number 85 of 2019. Whether the directions contained in the order dated 6/2/2020 passed in writ appeal 85 of 2019 has been carried out by the respondent director of health service. By the respondents. Same order, reflect the name of MS Bhattacharya. Requested to appear in the matter and obtain. Court master will furnish a copy of the writ appeal summons. Same date. Same date, 8th.
51.
Friday for draft. No, but what is being the budget and everything has been sanctioned. Approval is there.
Authority is dropping the DP law. They have
Dropping the DP.
And after that, he will the consequences for the whether he has already been dropped by his honorable court, but that case 19 or civil minor. He has already been dropped on 12/2019 or civil minor case 19. The part of the order is the violated. Paragraph 9. If he has already been. Page number 90, paragraph 9. First. Of PP, it has been closed by. Now the matter remains. Release of my return and benefits. In fact, in the last occasion, my lord, is on 17/7/2023. The same submission was made and lordship was pleased to grant in 4 weeks time. To comply with direction and was ordered to declare today for compliance. Today, we don't say declare definition. Can you pay the last order after this complaint? 17/7/2023.
Here giving you 3 weeks of time, last chance. Failing which we will initiate contempt proceedings. They are required, there is a specific order you have to comply. Mr. N. Upadhyay, Learned Counsel for the respondent submits. You are also appearing that appropriate instructions will be furnished before the court by the next date fixed in respect of the status of the compliance of the order. Regarding compliance of the order by the respondents, so he prays for 3 weeks further time. Mr. Decca, Learned Counsel, appears for the petitioner. Accordingly, matter be listed after 3 weeks, enabling the respondents to comply with the order, failing which court may proceed initiating contempt proceedings under Contempt of Courts Act, there will be High Court rules insofar as the respondents are concerned.
No, and let it expire. No, let it be 4 weeks or till then.
18th September.
Okay.
52.
It is the lordship. I'm paid for responding. The proceeding is in the final stage. We are just waiting for the comment from APSC. And as such, the promotion order is also in seal cover.
Where is it?
It is not with me, your lordship, but it will be granted as,
Mr. Bodhabur,
yes,
Learned Counsel appearing for the respondents, all the respondents.
yes.
Submits that the further time, prays for further time to complete his instructions regarding compliance of the directions of the court by order dated, ID order dated 13/08/2020, passed in the UPC number 2937 of 2020. List after 2 weeks.
53.
None appears for the decision. Same order. Madam, one more. compliance, whether status of the compliance of the directions and contained in the order dated 01/04/2019 passed in WPC 7539. Copy thereof being furnished by the court master. This one, but what date he had given? Eighth,
Lordship, kindly give another date, maybe on next day.
15th September.
54.
Await service reports on respondent 4. Now appears for the petitioner.
55,
Just after 2 weeks.
55 and 56.
Are Mazumdar not well? You prayed for some time to file a rejoinder. Have you filed it? It is submitted by learned counsel to the petitioner that no rejoinder affidavit is required. Therefore, since the pleadings are otherwise complete, matter will be listed for hearing. This hearing of what? This is against an interim order. Contempt is against an interim order. Huh?
It's against the final order. After the order, there was a significant some punishment has been imposed. And we filed a petition. Item number 55.
Why have you filed the contempt?
Granted directions from the court, founding the proceeding within the specified time. That time has already been expired.
But it is completed.
It is some sort of question. I have explained my position, but she was given the complete period. And there was some delay, and in fact, he has also joined related.
Joint means
He was
in the proceedings.
no, he was terminated from service. Then due to the court's order, he was again reinstated, the DP was proceeded. And the DP was completed, and there was, I do agree, there was a delay of 4 months. It also has been completed in August.
Heard learned counsel for the parties, this contempt petition has been filed by the petitioner. Alleging willful and deliberate disobedience of the directions contained in the order dated 22/04/2021 passed in WPC number 6624/2011. By the said order, the coordinate bench of this court issued the following, disposed of the writ petition with the following direction.
Page 11. There is no timeline, but they have to compare the complete the proceeding within the system. I have explained that in paragraph 4 of my application.
You start from the second paragraph, learn additionally, page number 11, straight, begin, stop. Where it is submitted that this direction was not complied with, and therefore the contempt petition is being filed. Where learned ASGI, Mr. Dev Chaudhary submits that an affidavit has been filed by the respondent, and it is explained as to why some delay had occurred in complying with the directions and stop. It is submitted, that is paragraph 4 of the said affidavit. The reasons for the delay have been properly explained. Stop. It is averred that during the period of April and May 2021, Corona was prevailing in Delhi NCR. And therefore, there was some delay which had occurred. in compliance of the state and in directions of this court. That stop that apart. By communication dated 23/06/2021, the petitioner, which was communicated to the petitioner through special messenger at his home. The petitioner was informed that he will be reinstated in service and a de novo inquiry will be conducted against him upon his reinstatement. Stop. The petitioner thereafter rejoined in his service on 2/7/2021. He was reinstated on the same day. Thereafter, the de novo inquiry proceeded against him. Stop. There are Mr. Pesborwa. No, you write one more thing. Yes, it was completed on
22/10/21.
22. The de novo inquiry was conducted and it was completed on 22/10/2021. Stop. Mr. Dev Chaudhary further submits that the by the same de novo inquiry, the petitioner was. What was the finding? What was the finding in the de novo?
Page 19.
Page
Page 9,
9,
19,
19.
19. 19. Paragraph 14. Paragraph. Beginning from the certificate.
Pursuant to the same de novo inquiry, the following order was passed. The order was passed with the following conclusions. Page number 19, para 14, conclusion 1, 2, and 3. Stop. Mr. Dev Chaudhary further submits that this de novo inquiry has been put to challenge in WPC 5253/2020. But in a subsequent writ petition filed by the petitioner. Stop. Where Mr. Pesborwa, learned counsel to the petitioner, submits that no rejoinder is necessary, but from a perusal of the affidavit, it appears it is evident that there was a delay in complying with the directions of this court, whereby the authorities were directed to complete the de novo inquiry within a period of 2 months from the date of receipt of a certified copy of the order. So, other counsels for 4 months, sorry. Other counsels for the parties have been heard, readings on the report have been carefully perused. While the direction of the court was to complete the de novo inquiry within 2 months, admittedly the inquiry could not be completed within the 2 months as directed. Stop. The delay for not being able to complete the inquiry within 2 months has been explained in the affidavit.
4 months.
4 months has been explained in the affidavit filed by the respondent number 1. Although no application for extension of time was prayed for by the respondents, seeking further extension of time for completion of the inquiry. Stop. Nevertheless, the inquiry was completed and the same inquiry report is under challenge in WPC number 5253 of 2022. Under such circumstances, this court is of the view that although some delay had occurred in compliance of the order dated so and so passed in WPC so and so, under the facts and circumstances of the court case, this court is not inclined to invoke its jurisdiction under the contempt jurisdiction under provisions of so and so, rating so and so. And accordingly, the contempt petition stands closed. Then WPC number 5253.
Elected respondent,
6 and 7. AD card has not been received. Who is appearing for 6 and 7? Six and 7 are the officers, I think. Who will appear? You will appear. The last office order dated 29/10/2022 reflects that AD card on respondent 6 and 7 has not been received. MSR Devi, learned CGC appears on behalf of respondents 1 to 5. You have received extra copies and you submitted that affidavit has already been filed. Stop. You want to file rejoinder? The learned counsel for the petitioner, however, declines to file any rejoinder affidavit. Stop. Let fresh steps be taken by registered post AD within 1 week from today on respondent 6 and 7. You want to take Dusty also? Stop. The petitioner is also permitted to furnish extra copies to the respondent counsel, who in turn will furnish the same to the, they are working under whom?
They are working under the respondent number 4.
To the office of the respondent number 4, namely Commandant so and so. Requesting the commandant to serve copies of the writ petition along with copies of the orders passed by this court on respondent 6 and 7. The extra copies we furnished within 1 week to the standing counsel to the CGC, who in turn, within a further period of 1 week, will transmit these copies to the official respondent court. That will be listed after 4 weeks.
Then 57. You look, I got a correction and you order it. 26/21. Or the wrongly mentioned the date of part of the.
Where is the order?
Order 21, 26/21.
Is not enforced to the IA.
Not, in our main revision. And really effective.
26.
26/2021.
(22/2) or 26. Huh?
26/2.
There is no order 26/2. There is an order 22/2.
I may be wrong.
You check up and make your corrections. List next week. List on Friday.
Next week.
Next week, all right. List next week. You check up and make. Don't correct by hand. You check up and inform, submit before the court, whatever corrections are necessary, you file it before the registry. In case required. Matter will be listed next week, enabling the learned petitioner learned counsel to the petitioner to complete his instructions and place before the court. Complete his instructions. Mr. Roy appears for the FCI, assisted by Mr. Spencer.
58.
Yes.
There are is present even of the application spending structure. RJ has already cleared the amount, struck the amount. And what
It is submitted that I number 1440 is infractuous. Accordingly, the same is dismissed as infractuous. Then. Oh, this is already closed. Okay. As the amount has been received.
not for the insurance, but sure.
All right.
They may find another appropriate.
I is filed by you
Yes, sir, for the claims.
for,
But I'm appearing for the claim.
so you are saying it has become infractuous? Yes, all right.
For hearing, top of the list, item 63.
None appears for the petitioner dismissed for default, non-prosecution. Interim order is any stand vacated.
Another item 59.
As per the conditions of law, they need to show matter, how whether food was not distributed without.
Court of inquiry.
Court of it. As per.
What have you found out?
Lordship, what I found lordship from the record and also in my exhibit has stated that the court of inquiry had recommended that he should be dismissed from service, and the commandant had agreed with that, and then he directed to so was notice. Subsequently, lordship, because security force code as per section 76, the commandant or the commanding officer of the force, he alone can constitute a force lordship. In my executive also lordship that
This is CRPF,
no SS
SSP. That doesn't. This is a summary court.
yes. Court of inquiry had recommended and agreed with the commanding officer directed to issue so was notice lordship. So section 82. A summary force could may be held by the commanding officer of any unit and he alone shall constitute the court. So lordship in as per that lordship, notice to propose notice was in lordship may kindly take up my activity lordship. This running phase in lordship will be lordship.
60.
The lordship. That's
Yes.
the there is lordship. The services of the petitioner was undesirable to retain in its armed force like SSB. Therefore, the disciplinary authority conveys court of inquiry on case 9K to find out whether the petitioner is suitable for retention in government service or not. Assistant commandant has submitted court of inquiry report filed later dated 13/9K. Based on recommendation of the court of inquiry, the petitioner was found unsuitable for government service. To meet the requirement of natural justice on 27/10, a so-called notice was issued by the disciplinary authority to the petitioner so that he may be able to put forth his defense or person in his case before taking penal action against the petitioner. The petitioner has submitted a representation on 9/1/11 in reply to the so-called notice. petitioner has been brought on 2/11 and the disciplinary authority advised him to submit resignation as per 26 of the SSB rule 2009 so that he may be able to get the financial benefit, etc. The petitioner, however, refused to do so. Besides, Corps Commander Akol was asked to submit confidential report of the petitioner for the last 6 months. Accordingly, after careful examination of the report of the initial Corps Commander Akol, the disciplinary authority in exercise the power conferred by 26 of SSB Rule 2009 discharged the petitioner from service on the ground of unsuitability violation of order dated 28/11. Lordship, now Lordship kindly take up 26 of the SSB rules, Lordship. 26 of the SSB rules, which itself provides that
Yes,
in the termination of service of enrolled person on the ground of unsuitability, where commanding officer not below the rank of commander is satisfied that an enrolled person is unacceptable to be retained in the post. The enrolled person shall be so informed, furnished with the particular of all major advice to him and call upon to add any reason he wishes to put forward in favor of his retention in his service. Provided that clause A, B, and C shall not apply to his penalty applicable applicability is to Lordship. After considering the explanation, if any, the commanding officer not below the rank of commander may call upon the enrolled person to retire or resign, and on his refusing to do so, the enrolled person may be compulsorily retired or discharged from the service. So that is followed, Lordship. On 2/11, we asked him to submit his resignation to get the financial benefit, but he refused to do so, and subsequently he was discharged from service.
now in 82, no doubt it is to be constituted by the commanding officer. But the proceedings are to be attended by 2 other persons.
Lordship. Yes, Lordship, that is there, Lordship, but the proceeding I have not found. But we have in his inquiry, code of inquiry, commander agreed, and then he directed his focus. Apart from that, whether it is constitution, he himself alone can constitute the code. Whether attended by other someone, that is not reflected, but he could himself alone to do that. And from our ability also that we have given him opportunity to personal hearing also.
No, you may have done everything. But this purpose of summary force court is to conduct a proceeding. So the proceeding must be available from some proceeding book or recorded somewhere.
Court is perhaps not if the code of inquiry statements were already recorded of all the witnesses. So maybe why?
No, now that is the question exactly. Are you saying that the court of inquiry can also be constituted to be a summary court proceeding?
But here it shows that it was issued by the commandant.
You come to section 82.
Yes. So our ability says that court of inquiry is, if the commandant has submitted report of inquiry, report of the court of inquiry, and thereafter commandant being agreed with the finding, he in his remarks he said that I am agreed. So that is there. Court of inquiry is by the assistant commandant and 2 other persons.
82 says it shall be held by the commanding officer.
Yes.
He will alone constitute the court, so he becomes a court. But the proceedings shall be attended by 2 other persons, who shall be officers or subordinate officers, or either or one of them, one of the either. But they will not be sworn or affirmed. So there it contemplates 2 things. Number 1, there is a summary force court comprising of only the commanding officer. Summary force court will have a proceeding. That proceeding is to be attended by 2 persons.
There constitution of any other that I have not found, but whether if the commandant himself can.
You complete your instructions to this, because this will depend on whether the procedure has been followed or not. If the procedure is not followed, then ordinarily that procedural benefit of procedural safeguard is to be given to the petitioner.
But if, in our education also, that.
Is not there.
It is
Not
not
there.
there, because in rule 26, give the power to the commandant, that, after. giving-
What do you say, Mr.
26
Ormia?
Yeah, my lord, what has done, my lord, which has, my lord, I did not price the court. First affidavit filed from 9/7/95/17. Filed by one Umesh Kumar P.I. Yeah, my lord, he filed the affidavit, lordship kindly turn to internal page of that affidavit. Page 4, he reflects about section 21 and 18.
Affidavit filed,
Filed by Umesh Kumar P.I. 9/5/17.
there is one affidavit by Paramjit Singh Slaria,
It is the subsequent. Prior to-
deputy affidavit.
prior to him, my lord, one file Umesh Kumar P.I.
Then this affidavit,
This is file on 25.
then there is a reply.
My lord, that, my lord, what this contention is written there, my lord. Lordship kindly have a look at the internal page of 4 of that affidavit, my lord.
Rejoinder affidavit. Umesh Kumar Thaplial,
My lord, up there.
yes.
I am a response number 3.
Paragraph number,
Internal page, paragraph 9 and 10. 10 is the operative.
yes.
May I read, my lord? With regard to the statement made in para 9 of affidavit in reply, the defendant states that the statement is the basis and not correct. He was awarded punishment of his life appointment with the feedback of provision by him under section 21 F. Absconding from so and so punishment has no coercive order concerned with the order of the discharge from the service or by the commandant so and so. On going through the past service on the record, recommendation by the inquiry officer has been found unsustainable in the truth of inquiry extension of the government service. Therefore, the discipline authority decided to discharge the additional government service administrative job or as provided under rule 18 and 20. Now, my lord, what happened, my lord, immediately after hearing, my lord, the present affidavit which has been filed by Paramjit Sinha. So now, my lord, we'll see lordship again, my lord, from the rule. Because, my lord, he has to proceed to a court, my lord, and 75, he has to dissolve it also after exam. Kindly turn to the rule of the assembly rule 75. What is rules police officer? Director General of Ali prescribed as the appointed person referred to as the police officer for discharge so specified. The duties of a person appointed under section 1 to take charge of the person confined to the area office to discipline and prevent the breach of the same by the person serving in the attached to the rule. Not sending anything contained in the sections in any person under the rule, any time errors detain so and so. Procedure is there. Then, my lord, 83 rule 83(3), my lord. If a full score after commencement of the trial is reduced below the minimum trial, so required under the he shall be dissolved. He has not acted anything, my of his own. One person is the inquiry officer giving me punishment. One person, my lord. And group 3,
No, as per the section, only one person is necessary.
my lord,
He is
but
not the inquiry.
he has to constitute, my lord. After conclusion of the
proceeding money, he has to dissolve it. Law is law, man. Rule 83, 2 lots of what is the 2 and 3, it takes about money. And for unauthorized absent, rule 21 is there.
2 and 3 of rule,
Rule 83, man.
rule 83.
Dilution of the force code. If the
Huh?
force code after the commencement.
Rule 83 is order of trial.
My lord, after that, what they have to do, my lord? Reduce the minimum number of organs also, if the on the account of the concerned judge or attorney as such.
This is general force court logic.
No, no,
Normally, my
rule,
lord,
Mr. Council, rule 83 doesn't talk about dilution.
my lord, what she will see just for a moment, on the account of. Sorry, for attorney, for the case that deputy the judge, attorney general or so general accused before finding is impossible to continue the trial, force shall be resolved. The authority after whom content of force code may resolve the state. See, my lord, it appears to me that the existence of the service of the.
You are reading from which part?
Rule 83, rule 83, I'm reading.
Rule 83 of what?
Of my lord, SSB rule.
2009.
2007,
He is reading act logic, section.
83, man.
You are reading the section.
Section, man. Sorry, sir.
Yes.
Just immediately below that, my lord, which is not bad, already done.
83 is for general force court logic, where criminal murder, etc. cases were.
This is force code. Your case is a summary force code.
My lord,
You are governed by 82.
82, my lord, but from the 82 is taken into account, my lord. There is no constitution of the court.
That is what we wanted to find out.
There is no constitution. He may be the person, but he did not constitution.
No, no, constitution is there. I think.
Constitution is not there. On the last day, lordship has not found. And
He
rule-
had,
Section 21 says, my lord.
he has given
And
his
this
remark.
section cannot be attracted against me, because absent specifically deals with section 21.
In the court of inquiry, he had given his remark that I am agreed and directed to his focus on it. He being the commanding officer lordship, he himself is the court lordship by as per section 82. So he has done that. Remark of the commandant, I agree with the finding of IO, issue so called notice. That is what it is stated, and subsequently so called notice was issued.
Inquiry recommended under section 21, and penalty have been given in some of them. Lordship has seen on the last day. They never recommended for dismissal from my side. The specific provision is there. Punishment is there, man. What punishment I am entitled to get, or I am likely to get, section 21. Without following section 21, they indicate they come.
Rule 20, that is followed lordship.
That cannot be in my case. Unauthorized absence is specifically mentioned by section 21. Absence without leave. On the other day, lordship has gone through.
Termination on the ground of unsuitability. We have to read both action together lordship.
Where the section 21 go, specific provision is there.
Lordship, the grounds of absence without leave. What ground, those absence without leave is there, Lord. Absent himself without leave, without sufficient cause overstay is being granted to him. So he had, here lordship, he had violated many laws, including the. Because he has disappeared from the training center also. So these are the grounds on when absence without leave is there, Lord, which can be punished, Lord. Section 21 doesn't say about punishment. Is there, Lord.
It's
Without leave
reflected,
of
it's
clear-
reflected, 21G says 3 years.
There, my lord, yeah. If
Is there-
Imprisonment up to-
Is there supposed to be summary post for yes, Lord, proceeding or anything is not there, but he can himself only constitute the court, Lord, and as per that. Suppose notice was issued and he was given ample opportunity, Lord.
All my lord, DGP or commandant my lord cannot travel beyond the law. So is punishment is there, my lord, section.
Who is to impose the punishment?
If it is punishment, my lord, it has.
On a
to be
conviction by a force court.
Force court. If it is so, my lord, even though it is not, the procedure lapse is there. In that account, my lord, the entire procedure. And I am a just mere constable, right?
What is the procedure for initiating the what are the provisions in the act or the rules laying down the initiation of proceedings for uh, uh, prior to issuance of termination or discharge from the force?
Lordship of the other day has seen my lord for the record. The recommendation was made by the inquiry officer to take action under section 21. Two of the procedure labs and my lord, all the unit enforcement. And here have proceeding has initiated. Therefore, not have acted on this. Which is it cannot be acted on. If it is so my lord, then they have need to have constitution my lord. This one also have not followed.
And he- NCR was also considered, Lord, the last 6 months, NCR was also considered before it being the discharge order. Lord. They found that it is unsuitable, so rule 26 comes in their effect. They are given asking to submit a resignation so that we will get a benefit, potential benefit, as per 26 two. But he refused to do so, Lord.
After immediately after conclusion of the inquiry matter, recommendation was made to take action again in section as per section 51. But that not has been done. State where matter escaping on the procedure.
What is the relevant rule you are referring to?
Same rule of SSB X and SSB
No, rule number
26.
26.
26 rule cannot be applicable.
Hmm,
This 26 rule, our rule, my lord, cannot be applicable.
right,
Because my lord, recommendation was made to take action as per the.
you show us from the act and the rules that the recommendation of court of inquiry is binding on the commanding officer.
My lord, even governing officer, my lord, constitution itself is the wrong,
Why?
because there is no constitution, my lord. Without formal procedure, my lord, how come he can exercise? Of his own motion cannot. Be. That's very hard.
It is to be constituted by the commanding officer only.
But no constitution is there. My lord. Power is there, my lord, but it did not constitute. And I am with a small employee, my lord.
Yes, in his remark also no other.
And this is not, my lord, willful or voluntary. My wife had so many cases. One and after another, which I have an expert. At least there should have been liberal, my lord. It is not a misconduct on my part. If it is a misconduct, my lord, the punishment is otherwise, my lord. It is not that, my lord, I caused the harm to the foods. It is, my lord, my family trouble, because of which, my lord, I have to frequently go to the appear to the court.
Yeah, I have nothing to say, Lordship, the defense lordship, and course and personnel and public lordship, defense lordship is the most differentiate lordship, and the patient judgment also lordship, and keeping the record and patient judgment for a time period, not.
One more thing, my lord. The harsh punishment was accorded. That too down, that too a procedure. That. This that is of my lord. We will also come with lots of respect and so much. Without respect, as the-
You are a man of discipline force.
My lord, discipline is discipline, my lord.
Then
There is no, my lord,
what is the judgment?
deliberate or not.
And record for your point.
What is the judgment?
Modern Prasad, ex-people Modern Prasad, certificate, ma police judgment, recent one.
Foreigner home and once procedure lapse, everything is.
You show us some authority.
Authority, my lord, at this moment I cannot answer by.
There is no question of supply. You have to support your arguments on the basis of the authority.
Foreigner home, my lord, procedure has to be followed.
That's what I'm saying. These submissions that you're making
As law supported by the.
has to be traced out to some force of law.
If it is safety, my lord, tomorrow morning, my lord, I'll supply. Copy of the task. At this moment,
What will be the use of supplying these copies? We can take it out ourselves.
my lord, I can.
We have to hear you on how you are correlating these authorities with in support of your
Some
something.
judgment of the. Foreigner home, my lord, section 21 is applicable, my lord, 26 with the half cannot be applicable.
Friday, we'll keep it on Friday. Not Friday, Monday, next Monday, 28th. These are original records. You keep it with you for the time being till Monday. You hand it over on Monday. Hard councils for further hearing on Monday.
Item number 60.
I don't blame another board. I don't relate another board. We cannot be.
All right, items 63. Huh? Your matter is item 63. Let us see what is there in the matter. Oh. Let it be on Friday. Friday. Item 63 on Friday.
Item 60.
Lordship in item 60 as per Lordship direction Lordship on 8/23. We are supposed to have the additional affidavit Lordship. It's ready Lordship. I am just taking 1 week time. Bring it on that number.
All right. The promotion. Fishery department.
Yes, Lordship.
1 week's time she is praying for. Whatever promotion, if you are entitled, you will get your benefits. At the request of MS Chaji Leonard, additional senior government advocate, matter stands adjourned for a week, enabling her to file the affidavit.
Yes, Lordship.
On behalf of the department. Mr. Fupan appears for the petitioner list after 1 week. On 18th September.
Item 64 and 65.
What is the matter about?
Protection officer non-instituted as in the department of. He applied for the post of protection officer. And he applied as a OBC category. Out of order, he has not been appointed. And candidate secured marks, then he were appointed. Our defense system, so he was applied as a OBC candidate, it was not considered. That is our, therefore, the record has been called for. And regard to,
Lordship, I'm appearing today only Lordship. I'm just taking this time, 10 time. Lord.
So have the private respondents been served? They are appearing, you are appearing or affidavit.
The record of available Lordship, Lordship takes a short day, Lordship.
Have you filed your counter?
Yes, yes.
Affidavit filed by the government, yes, Lord. This is some record of it.
Thinking the Lordship, have to see whether I have applied as the OBC candidate or not. That is the issue. I have applied as the OBC candidate, I have a case. Otherwise, Lordship, I have.
there was a direction of sort of report or something, one was second also. One to come, this is significantly order.
It's any next week, Lord.
At the request of this Land Council for the General Senior Government Advocate, matter stands adjourned for a week, enabling her to go for the relevant records. For perusal of court if required. Mr. Aloy for the petitioner, Mr. D.K. Mohanto, D.K. Roy for the private respondents.
5, 6, 8.
Private respondents, all the private
No
respondents,
matter except 7.
all private respondents except respondent 7. Matter be listed again on. Part heard, we've not even heard, we've not even opened, we have not even opened the hearing. No, time is there, but you want that the records are necessary to peruse the records. If that is the only issue, then let the records be there. 21st. 20th, 20. September, 20 September. All right.
তার নাম তো দিয়ে দিব এইচ করবো
Friday, no? Friday is good.
25.
ঠিক আছে, তাই তো।
কিন্তু এটা হেরে গিয়ে এটা কি করলি তুই পাস অর্ডার দিয়ে দিন এই ফ্রাইডে মাত্র এটা পিও জানে না এটা তো যে এটা প্রথম ডিসপোজ তার সাথে যে ডাব্লিউপিসি যে পেন্ডিং এটা ক্লিক করে দিলে না আছে সাইডেশন হ্যাঁ কি কারণে আনে বা আরে বলে মারি এসো জানা না এই ওষুধটা জানি মো বহুত কমে রুটি যাও
এটা টেকনিক আছে